Justice Research Foundation voice for giving me this opportunity to be present here at the Validatory and share my experiences as a journalist since I joined the Indian Express way back in 1985 as an apprentice sub-editor at the Indian Express desk in Fort Cochin. That's a place where you see this biennial Kochi Biennale takes place every 2 years. That part of the Aspinwall building was where we had the desk at those days. Whenever I go to Biennale, I would tell Bose Krishnamachari that I happen to be here even before you had set foot on this soil at Aspinwall, because I started off as an apprentice sub-editor there. So to be amidst lawyers and legal pundits, it's a very trying task, because you would X-ray every word of that I say, and I can go wrong. So in case I'm taking an anticipatory bail, that should I commit any legalistic offense, pardon me. And we all journalists of those days, of the vintage, we did not have proper journalism degrees. All that those people were privileged to have at that time was just the diploma, which was awarded by the Institute of Journalism, Trivandrum, which was started in 1968 by the legendary M. Shivram. When I say the legendary M. Shivram happened to be the Press Trust of India PTA correspondent who first got the assignment to cover a report from Beijing. And he smuggled in as some other organization worker to go to Beijing. If he had flaunted his credentials as a PTA correspondent, he would have never been able to go there. So he went under disguise as somebody else and started reporting from there. So that was the great occasion. That was the iconic status of the Institute of Journalism those days, 1968. A person who was almost like Subramania Swamy when emergency was declared. He went in disguise, came out of parliament and smuggled himself out of the country. So some such valiant acts being committed by a journalist, that very same journalist there to teach what is reporting, what is editing, what is international journalism, all that. So those days, it was all that was there. So in 1985, when I joined the Express, I only had a postgraduate degree in English literature. I did not have any journalism degree. So what we say is that we learn things on the job. It is what I learned on the job that I'm trying to share with you here. Maybe it's some use to you. If it's useless, I'm sorry, that's all I know. Anyway, I don't think I'll let you down on this, because these are experiences that exclusively mine. And some of those sitting here may not have had this experience. So I think it is okay. I get along with this. My first brush with the court verdict, that was way back in 1985. You must, though some of you were not born then, you must have heard of the great Punjab model speech by the late R. Balakrishna Pilla. I don't know whether you've heard it. And then Balakrishna Pilla made a speech in Ernakulam saying that we should go the way of Punjab, Kerala. Should go the way of Punjab, militant, extract maximum concession from the center. That's the only way Kerala can flourish and go forward. That's what he said. And this speech was said to be a violation of the oath that he had taken as a minister. So and this went in litigation. And the most reported litigation, the story of the day was the Punjab model speech of Balakrishna Pilla. And you had two legal luminaries coming and arguing the case in the court. The presiding judge was, of course, then Justice V.S. Malibat. He was Chief Justice of Kerala High Court. And the lawyers were, both of them are alive, veterans, K.K. Venugopal, then K. Parasharan. So I said my first brush with court proceedings was to listen to these two stalwarts arguing. it was easy for me to listen to K.K. Venugopal. K.K. Venugopal, his accent and his very clear modulation and intonation, it is appealing to a person like me. I would try to understand and grasp what he says. Whereas Parasharan, with one of his legs perched like this on a small stool, he would always like that, with lifting his right leg and addressing the judge. He would have a small stand in front of him where he would keep the book, and then most of what Parasharan said, I couldn't follow. And I gathered the impression that the judge remained so unimpressed by Parasharan's delivery. I held this opinion for a very, very long time, that a man who could not impress an ordinary, a young sub-editor from Indian Express, I thought would not be impressive, would not impress the judge himself. But this fallacy of mine, or this fallacious perspective of mine, how judges would be impressed, the presiding deities in the court would be impressed, was totally blown apart years later when I discussed this, when I narrated this anecdote to a young lawyer in the Supreme Court, in the High Court. And he said, John, the delivery of Parasharan, which you found to be incomprehensible, was fully comprehensible to the judge. K.K. Venugopal impressed you because his language, the delivery, the clarity, the pronunciation appealed to you. The content of the legal argument is more important than the fashion with which you deliver the argument. So that is what ultimately carries the day. And I think so. That's why Parasharan went on to climb dizzying heights in legal positions in the center. He later became a member of the Rajya Sabha, and his son Mohan Parasharan, also a great luminary. So this was my first brush with court reporting, though I was not a court correspondent. This is a lesson that I learned later, that it is the content, the cogent argument that you make before the judge is what matters more than the language. Language is fine, but if you try to speak a better language than the judge, I wonder what would be the outcome of the litigation. So I know there are several lawyers who would be very subdued when they deliver the arguments, lest they should be seen to be showing off their linguistic skills. That would draw sort of sneers from of course, the judge, the presiding judge wouldn't do that, but that sometimes could be counterproductive. Again, that was told to me by another lawyer friend of mine. Yeah, when we mention K.K. Venugopal, perhaps the teachers sitting there might know, or I don't know whether how many of those people who are still learning the law would know that, because K.K. Venugopal's father, the legendary Barrister M.K. Nampiar's case in the High Court of Madras, seeking the release of, again, the legendary trade union leader and later the opposition leader in the Lok Sabha, A.K. Gopalan. And that was the habeas first, I think, the very much discussed habeas corpus case. Habeas corpus, as you know, is to bring the person to the court. Bring the person. He's not to be seen. He's in detention. So, Venugopal and M.K. Nampiar. You have got the M.K. Nampiar Endowment Award being given by K.K. Venugopal now. K.K. Venugopal, I know, we heard him directly tell a small group of journalists long time back that he wanted to start a big institute here in Trivandrum, but not here in Trivandrum. He wanted to start long back in Kochi, and he gave a check of 1 crore, rupees to the late Sushila Gopalan, the minister, but that did not materialize at that time. Okay, these are all small stories inside stories that I was privy to, so I thought I would spare that. I would share it with you. Yeah. Then I got a taste of litigation when I tried to unravel the mystery behind one of the major frauds happening at that time. There was a judgment by the judge is still alive, so I don't want to mention his name because names, more than the names, the facts that I know might interest you. There used to be a great fraud committed on the exchequer of the state government by contractors who would undercoat, and there would be a cartelization. Cartel, a group of, people coming together with their ulterior motives to make an easy pie on the government. They would form a cartel. So if suppose I have a cartel of contractors in my group, there'll be 5 or 6 people of the contractors, and there is a particular work coming from execution of the irrigation department or Kerala Water Authority, then we ourselves would come into a dubious agreement ourselves, a conspiratorial agreement among ourselves saying that, I would quote for 10 rupees. Actually, the work demands at least 20 rupees, for instance, but I would quote it for 10 rupees. And because my quote would be the lowest bidder, I would be the lowest bidder, all the other people would quote much less. And I would get the bid. The auction would come in my favor. I would get the contract, but I would never be able to execute the contract because the amount of contractual money that I get would be far too insufficient to execute the contract. So I would raise so many hurdles in the process of executing the contract. Then finally, the department would become weary of me. Then they would refer the case, my case. That is, the contract is not being executed. There is a time and cost overrun. It is causing losses to the exchequer. So this case would be referred for arbitration. And there begins the arbitration fraud. It will be a nexus among the contractor, the government pleader, the engineer, and in many cases, this civil code officer. And this arbitration would go on. The arbitration award would first maybe say 5 lakh. The contractor would say, no, this doesn't meet my demand. The arbitration would climb every ladder and go right up to the High Court. And in this particular case, there was the contractor from Northern Kerala. He was from Malabar. I still remember his name. The second name has got a Haji in the name. I wouldn't want to mention the full name. And this case, this arbitration fraud went to the High Court. The High Court, the then acting Chief Justice, said, this is a huge fraud committed on the exchequer. The petition before the High Court was to grant an arbitration award to the contractor. The contractor was not fully satisfied with the award that he got at the lower court. And you know what the judge said? This is a fraud committed as a result of the nexus between the contractor, the engineer, lower court officials, and the lawyer. Okay. And then you know what the judge said? I am closing this case, bell, book, and candle. Bell, book, and candle is an expression that is used in canonical law for excommunication. When a Christian is being excommunicated from the church, they would ring the bell. They would close the book, the Bible. Then they would put out the candle. So I close this case, bell, book, and candle. And this is what is reported. The great judge of the High Court has put a final chapter to the fraud committed on the exchequer, and he has thrown out the petition and saved lakhs and lakhs of rupees for the exchequer. But what happened? The unreported part of the judgment is this. This was never reported. And this is conveyed to me by the then Law Secretary of the State of Kerala. And you know what he told me? The judge, after dismissing the case, bell, book, and candle, summoned the Advocate General, the Contractors' Council, to his chamber and said, now what do we do? I will appoint another arbitrator. The judge, while closing the case, appointed another arbitrator. And I know the arbitrator was given an arbitration fee of 5 lakh rupees. And an award was given to the contractor from North Kerala, but this part of how this litigation was resolved was never reported. That remains an unreported part. In fact, I took it up with one of the ex-judges of the Supreme Court. I couldn't stand this kind of a fraud being committed on the people of Kerala, on our democratic system. So, you know, I was a reporter with the Indian Express then in Trivandrum. I went to Kochi to meet this great pundit of a judge. But the moment I told him the name of the judge who sat in judgment on this case. He said, nothing doing. I will not take up this case. So that was a major dilemma that I faced. I faced myself as a reporter because my legal background is nothing. I am not competent to understand the nuances of the law. I'm not able to understand fully what the judgment, the implications of the judgment. So I thought rather in exposing this, I would be helped in large measure by the retired judge of the Supreme Court. But the moment he came to know the name of the judge who delivered the judgment, he withdrew. So I had to come back sullen from Kochi and came back to my bureau in Trivandrum, and I told my bureau chief that this is what happened. This is what happened to my effort to unravel the mystery behind this arbitration fraud, in which the judge gives a judgment and the crucial component of the judgment remains unreported. It is judge himself who looks at the report that is being sent to the law journals. So this is an experience. Then I wanted to write a book on the infamous judgments of the High Court. There are several infamous judgments like this which have happened. Again, I'm hamstrung in doing it. Possibly someday some other person who is a reporter and who has got legal background, who is legally qualified, might be able to take it up and then expose the fraud. When Ranial asked me about what when I asked Ranial what I should be sharing with you at your valedictory, she said whatever you have come across and whatever you have noticed as a reporter, you can discuss with us. What I have noticed as a reporter is that one is that the Malayalam English ego clash. Judges who are well grounded in Malayalam, when they happen to be writing judgments, they invariably write it in English. So there is always this kind of a fight between this kind of a ego clash. What you see on in some of the campuses where you got the Malayalam professor is very good at Malayalam. He somehow wants to show. He wants people to understand he's also equally good at English. So he starts speaking English like the English professor. Often he falls between two stools. That kind of a dilemma often I see, because some of the finest judgments, judgments is given in a very poor, clumsy translation. When you read that judgment, this judge has thought all this in his own linguistic base, that is Malayalam, in his vernacular base, and then he has tried to translate this into exquisite language, a different language than his native language. Thereby, he makes it very clumsy. Who can tell the judge, sir, this translation is very poor, can't do that? I heard the other day there was a function at the press club when Adu Gopalakrishnan was telling us that, this great Garcia Marquez writes in Spanish, Latin American writer, but he has become famous all over, not because of his Spanish, because of the excellent translation of the original Spanish literature. This is what is lacking for us here. If only our judges had some person to assist him translate it better, the expressions would be different, and you would have got better fine judgments for us to read. This is one variety of judgment that I have found. Often we would come to laughter, or we'll be in splits reading the judgment. The other is the very opposite of that. I've heard of a judge who would write very lucid, simple, measured judgment first. That is a first draft. He will keep that draft there. Then those were not the days of Google. So he would ask his confidential assistant to bring the dictionary. The dictionary would be brought in, and all possible simple words would be supplanted with difficult words. He had a passion for us. It is a fetish for him. And that judgment would be so abstruse, nobody would really understand what is the meaning of it. Maybe the operative part of the judgment would be clear enough for others to read. But the process, all the highway that you travel up to the end of the operative part of the judgment would be littered with such vocabulary that I am sure even Dr. Shashi Tharoor will not be able to translate it easily for you. This is the situation. And have you not seen that Shashi Tharoor? Shashi Tharoor has got a very bad name as a person who uses hard words. No, that is a misnomer. That is a misinterpretation of Shashi Tharoor. Shashi Tharoor writes in the best, simplest of English possible. Except that he often digresses into some hard words to titillate his audience. He is never ever does he believe in writing hard words and in confusing people. Look at all the editorials that happen across India now, across the world. The editorials are the best, easiest things that you can write. Very cogent in the argument, very lucid, and very simple English. Of course, when you write simple English, there is a possibility that you are simple. If you are not a master writing simple language, you could end up being very simplistic. You know the difference between being simple and simplistic. Simplistic is trying to break down a very complex thing and make it appear simple. In the process, that you lose the heart and soul of the matter, and you make it very simplistic. For instance, I remember now about the judge I told you, that person who uses very hard words and very harsh words. You know, I remember I can only try to tell you this evening at the valedictory that almost it sounds like Dr. Samuel Johnson. You know the famous Samuel Johnson delivery? Allow me to enter my digitorial extremities into your odoriferous concavity to extract therefrom some of the pulverized atoms of tobacco. When it passes through the nostrils, it creates a pricking sensation to the olfactory nerves. You know, what was he meaning? Allow me to have a pinch of snuff from your snuff box. So this is the way in which some judges would prefer to write now. They would pretend to be masters of the language. They are clones of Dr. Johnson. But Dr. Johnson used to do that. It came very naturally to him, and there is a certain way we could appreciate it because it stood out for its quality of a language. So yeah, next I'm coming to this. I cannot. One of the challenges that always reporters have felt with regard to reporting code is to break down very strict legal terminology into a language that can be assimilated by the ordinary folks who read the English language. You in courtrooms are suffused with so much of Latinism that it is very difficult for an ordinary person to understand. For instance, a professor who taught us Milton, Professor Belram Musaddin, Fatima College, Kollam, he once told us about this habeas corpus. That was the Rajan case and all that emergency and all that. Then he mentioned, he asked us, what do you mean by habeas corpus? He told us, he explained to us in very simple terms, bring the body in person, bring the person. Him, body is dead. Not bring the body, bring the person. So these are all lost on the average reader. You will have different kinds of terminologies or a repetition. Who knows what it is? And it is very difficult. Again, only one person in my entire career have I seen to be doing justice to legal reporting was the former Lok Sabha MP, Sebastian Paul. Dr. Sebastian Paul. He was equally at home in Malayalam and English, that he would send a copy for Deshabhimani. He would also send a copy for the Hindu. That was the best ever legal reporting that I have come across. I don't know whether, yes, he had secured a law degree much later, but it started, the law degree came much after he started his brush with legal reporting. So again, you would find that, this kind of fixation, obsession of the reporters with using the terminology. Sometimes they are so obsessed with the terminology that they would want to reproduce it and show off to the readers as a manifestation of their erudition. For instance, somebody can be admitted in hospital with the brain bleeding. But what is the thing that doctors will tell you? Cerebral hemorrhage. So if I tell you it is just bleeding in the brain, what is a big deal about it? When I tell you cerebral hemorrhage, yeah, that's something really important. So reporter's job, again, the challenge is to simplify the terminology and interpret it in a way without committing any offense, without corrupting it to the average reader. So they understand. We have tried to do it. Those people sitting at the desk would try to do this. But again, it is a very tall order, because it's not easy. Most of legalisms, most of them appear worse than Greek to the sub-editor sitting there. So that is it. And I tell you, I can confess to you that we poor journalists, media persons, whether we are sub-editors or reporters, for a long time, we wallow in our ignorance because we do not know the difference. The great Aristotle said, the greatest human fallacy, to know something, to believe, to think you know something when in fact you do not know. This happened to me. I can, in a very autobiographical way, I can tell you, I thought the difference between bailable and non-bailable offenses. I thought, some offenses are so severe, you would never get a bail. It is after a long time that I understood, rather I came to understand, certain offenses are minor, that the man in khaki can give you the bail. There are other issues involved which only a judicial authority can grant a bail after taking note of the state of offense. So journalists often have this, kind of ignorant assumptions about what is happening around, and they would go on arguing about what they know. And again, so we come to that point where why should we be quarreling? We lawyers on one side and the media persons on the other side should be quarreling. We are opposite sides of the same coin. Like in the sense lawyers are doing a very, very worthy job as people of the judiciary. That is the judiciary, like parliament and the executive and all that, the three pillars. And then we are the media persons happen to constitute that unmentioned, unofficial for the state. So why should we be quarreling? I do not know. We are performing complementary roles. Complementary roles, we don't have a seat in the court. We just come there because it is not as long as it is an open public trial, the members of the public can come there. It is by virtue of that logic that we come there to see and understand what the trial poses, what is happening at the trial stage. But often lawyers think, these second-class citizens, they have absolutely no idea of what is transpiring in the court. They have come here like, strangers. They don't understand anything. So always they look down on you, and finally the tensions erupt at some point of time, and there are clashes. So again, so the only prayer that I can make to you, you young people, young lawyers, is that, treat the media persons with some compassion, be nice to them, tell them that, there are certain provisions of the law, so there are certain parts of the trial process that you may not be able to understand. You come to us, you come to our room, we will let you know what exactly is happening. So that kind of a bridge building would serve the best interests of society. After all, the Law and Justice Research Foundation is trying to propound constitutional philosophy and enlarge the scope of awareness among the masses, among the people. So, and you have ventured yourself getting into a great project of creating one law graduate from each ward of a local body. So these are all very noble things that you're doing. So the same amount of attitude of cohabitation with other segments of society can be adopted towards the media also. I'm sure many of the people sitting in the holding responsible positions in the, whether it be a newspaper organization or whether it be in the broadcast center or whether it be in new media, they would be responsible enough to listen to you. You just talk to them, and much of the friction that you see on the ground can be removed that way. Let me see if there is anything left that I can. Yeah. And again, reporting a court judgment, we refer to different types of intro for a report. I remember there is one headline in the Indian Express. I never saw the headline in print, but when we joined the Indian Express way back in 1985, the folklore there was about a sterling headline, once which the Indian Express contributed. A man presumed judge makes his appearance on the day of the judgment in the court. A man presumed judge makes his appearance on the day of the judgment in the court. And that smart sub-editor who edited the story, you know what is the headline? Justice walks into court. Justice walks into court. That was the day I felt enamored of the profession of the legal profession. So there are wonderful things happening in the legal profession, but I tell you that you cannot, you as a segment of society, as a professional segment of society, you cannot play with the copy. If I go to a place and I want to report, I can possibly do a feature on it. But when you report a court verdict, you have to follow the staccato, the typical inverted pyramidal style of reporting. Do you have any idea of what is an inverted pyramid? The pyramid with the zenith tapering like that and the base on the ground. That is a normal pyramid. But in journalistic reporting style, we have a structure called inverted pyramid. In nowhere on earth does an inverted pyramid exist in any concrete form that way, but only in the way that we fashion the story writing. When we compose the story, we bring the 5 W's and 1 H right on top of the copy. The most important part of the story would be there compressed into a very concise thing in the intro part. That intro of comprising intro in say about 20 to 30 to 40 words should tell you what exactly this style of reporting is applicable in court in reporting court proceedings, because there the story has to be given in its descending order of importance. The most important part of the story would be right on top, just like the inverted pyramid. The main components of the story would be right on top of the copy, and then it will slowly taper down. So in the olden days, if the story was a little large, little long for the paper, the man who makes a page can chop off from the tail part, because he would be taking out the least important part, which would be there at the tail end. I tried to tell you about various different types of intros. No, I don't have to mention any other type of intro. The only intro that is applicable to legal reporting is the inverted pyramidal style of intro. And again, in simple words, what is an inverted pyramidal style of intro? A story is structured and composed in the descending order of importance. The most important part is right on top. And it comes down into a triangular form, and the least important part is at the tail end. So I think I have exhausted my energy, and I have exhausted all your patience also. So I think I should thank you once again for this giving me this opportunity. And I think I have shared with you my major experiences in the brush with court reporting, though I have not reported court as it is, except of course when some verdict is being sent to me and I have to make it. Before winding up, I'll tell you, the first time I tried to report a court verdict. I took hours and hours together because I didn't know who is the litigant, who is the plaintiff, and who is the respondent. So I was reading the entire text. Some 50 pages was there. Then the bureau chief came and told me, John, how much of time do you take to do this report? I said, this is a lengthy. I mean, it's such a thick judgment, some 50 pages. Otherwise, I know I can commit a blunder reporting. Then he said, go to the operative part. That is in the last part of the judgment. Go to the operative part. That is your intro. Get it. Then you have any doubts, go back, at random, go and do it. And if you want to read the entire text, you can take it home and read. At the bureau, you don't have the luxury of doing it. Just like the Franco Molecule case. How many days, how many hours people tend to read it? I have tried to read it in full, not fully. Before I have read it in full, I have read so many analyses of it, both for and against the judge to deliver the judgment. And I read one with an analysis given by the former Aam Aadmi Party here, Ajit Joy, the former IPS officer. He gave an analysis. I read that. Now I do not too confused. But I only know that, a judge delivers the verdict based on the arguments and the material evidence before him. Whatever the rest of the world says, he needs to insulate himself from all that. Thank you for listening to me. This great opportunity given to me. We will keep this relationship that I have been able to, this budding relationship with you. All very bright faces before me. Thank you. I'm sitting next across there at the press club. There is the institute building, Institute of Journalism. We've got some students there, very avid people. They're all there in that festival mood there. I can't tell them any journalism now. It's different things are going on there. So I did not want to invite them to this. Rather, I would have taken them here. Okay. Anyone interested in talking to our students, come over there. Thank you. And good day to you all.